Affiliated Business Arrangement Disclosure Statement, Transparency, RESPA compliance, and consumer protection. We now move into one of the most important federal disclosure requirements in real estate transactions, the Affiliated Business Arrangement Disclosure Statement, often called an AFBA disclosure. This disclosure is required whenever a real estate brokerage has an ownership interest or financial relationship with a settlement service provider and refers clients to that provider. This is not optional. This is not marketing. This is federal law under RESPA, the Real Estate Settlement Procedures Act, 12 U.S.C., paragraph 2601 ED SEQ. If your brokerage has an ownership interest in a title company, lender, home warranty company, 1031 exchange accommodator, or similar settlement service provider, you must disclose that relationship to all parties at or before referral. Failure to properly disclose can result in federal penalties, civil liability, and potential disciplinary action. What is an affiliated business arrangement, AFBA? An affiliated business arrangement exists when a person in a position to refer settlement service business, such as a broker, has an ownership interest or financial relationship with a provider of settlement services, such as title, escrow, lending, or home warranty. If a referral is made and there is any potential financial benefit, disclosure is required. Generic example for instruction. A brokerage owns part of a title company and refers a buyer to that title company. Because the brokerage benefits financially, the buyer must receive written disclosure explaining the nature of the relationship. That the buyer is not required to use that provider, that other providers are available, required elements of the disclosure under RESPA. The AFBA disclosure must clearly state the nature of the relationship, ownership percentage or financial interest, an estimate of charges or range of charges for services, that the consumer is not required to use the affiliated provider, that other providers offering similar services are available, that the consumer is free to shop around. This is consumer protection legislation designed to prevent steering and hidden kickbacks. Important legal distinction: AFBA versus illegal kickback. RESPA prohibits giving or receiving anything of value for the referral of settlement services unless the relationship qualifies as a properly disclosed affiliated business arrangement. The referral is not required. The compensation is based on actual ownership return, not per referral payment. If a brokerage receives a per-file referral fee without ownership interest and without disclosure, that may violate federal anti-kickback provisions. Common settlement services that trigger AFBA disclosure title and escrow services. Mortgage lending, home warranty companies, 1031 exchange accommodators, insurance providers, if settlement related. Arizona brokers must understand that this disclosure applies whether the company is wholly owned, partially owned, or financially tied in a way that produces benefit. Estimated charges requirement. The disclosure must provide estimated charges or ranges of charges for the services. Example: structure for instruction, title services, owner's policy premium based on sales price, lender services, origination fees expressed as percentage range, home warranty, annual premium range depending on property type, 1031 exchange, flat fee or range depending on transaction complexity. This is not a guaranteed price quote. It is a range disclosure. Marketing arrangement disclosure versus affiliated business arrangement. These are different disclosures. An affiliated business arrangement involves ownership or financial interest. A marketing arrangement disclosure applies when a vendor compensates a brokerage for marketing, advertising, or promotional services, but there is no ownership interest. Even if there is no ownership, disclosure may still be required under consumer protection standards, including UDAAP, unfair, deceptive, or abusive acts or practices. Sub-agency disclosure. If related brokerage entities operate together and share fiduciary duties or sub-agency relationships, disclosure of that relationship is required so the client understands who may be acting on their behalf. Transparency reduces later claims of undisclosed relationships or conflicts of interest. Critical teaching point disclosure must be given to all parties. If your brokerage has an affiliated business relationship and refers a buyer or seller to that affiliated provider, the disclosure must be given to the consumer at or before referral, not after closing, not buried in paperwork, not optional. Phoenix example. A brokerage refers a seller to its affiliated title company. The seller must receive the AFBA disclosure before or at the time of referral. Consumer freedom to choose. The disclosure must clearly state that the client is not required to use the affiliated provider. There are frequently other providers available. The client is free to shop around. This protects consumers from coercion. Broker risk management. Never condition representation on use of affiliated services. Never imply better treatment or faster closing solely due to affiliation. Never fail to provide written disclosure. Maintain signed acknowledgement in transaction file per ARS, paragraph 32-151.01 record retention requirements. Course discussions with answers. Discussion. Question. Why does RESPA require affiliated business arrangement disclosures? Answer. To prevent hidden kickbacks and ensure consumers understand financial relationships that could influence referrals. Discussion. Question. If a brokerage owns 25% of a title company and refers clients there, is disclosure required? Answer. Yes. Any ownership or financial interest that results in benefit requires disclosure. Discussion question. Can a brokerage require a buyer to use its affiliated lender? Answer. No. Consumers must be free to choose other providers.